tabletop and IP. Our talk today is called Don't Roll the Dice and IP. And with us, we have a panel of three distinguished IP knowledgeable people. Okay. I hope you guys have fun today. My name is Ramon Mercado. I'm a patent examiner of 14 years now, originally from Puerto Rico, now living in Virginia. Now, in the past year, I've been able to help spread education and help with the demystification of the IP uh, information through the outreach office, in particular with the Northeast Outreach Office here in Alexandria, Virginia, where the USPTO headquarters are. With me today, we have Rebekah Oates. She holds a BA in history from Gettysburg College and an MA in public history and 19th century US history from West Virginia. Becky previously worked for the National Park Service in the field of historic interpretation. Currently, she serves as the USPTO historian. In this role, Becky seeks to inspire innovation by telling the stories of past and present inventions, entrepreneurs, and trailblazers, as well as maintaining a robust repository of institutional history. Today, we also have Brian Chellgren. He's a partner at Denton's, the largest law firm in the world, where he served as a co-leader of intellectual property and technology practice group for the United States region. Brian is a registered patent attorney and a PhD biochemist. He served as outside counsel for the Game Manufacturers Association, GAMA, the trade organization for the U.S. hobby gaming industry, and regularly advise game designers, developers, and publishers through the world on intellectual property and business matters relating to the industry. And we also have Justin Jacobson. He was a civil litigator in South Florida for more than 20 years before hanging up his briefcase to become a board game publisher. As the owner of Restoration Games, he brings back games from his youth and gives them a fresh coat of paint for today's modern games. He currently lives in South Florida with his wife, two daughters, a dog, and a cat. I won't hold that against you about the cat because I'm a dog person, because you develop so many great games. All right. So, like I said, hopefully you guys can enjoy this talk today, and we learned so much about IP and tabletop. So I'm going to let Becky start our discussion. So Becky, take it away.
Fantastic. Thank you so much, Ramon, and thanks to everyone in the audience for being here today. We're really excited to share some information about intellectual property in the gaming world with you all. So I'm just going to pull up a few slides. Hopefully you all can see this. If not, if someone could give me a thumbs up, that would be great. Ramon, can you see the slides? Oh, perfect. Thank you. All right. So we are today going to kick off things talking a little bit about tabletop gaming from a historical perspective, and then the two speakers, Michael and Justin, after me, will talk a little bit more in a modern context, but kind of how this all loops together is there's some connections between kind of these historical trends in gaming and what we kind of know and love as the tabletop gaming world today. So to start off, like as many of you likely did, I grew up playing tabletop games, and game nights are still a cherished pastime for my family today. I personally favor strategy games over game of chance, but I'm willing to roll the dice on anything new. So always looking to kind of expand my knowledge about the board game world. My game shelf is a combination of classics and vintage games and some newer games, and I suspect that holds true for many of us. But one commonality with all of these is that these games very likely have some form of intellectual property protection, whether that be a trademark for the name of the game or the brand that developed it, a patent for the way the game is played or how it looks, or copyright protection on some of the art. So our other speakers are going to delve more into the specifics of how different types of intellectual property protect the aspects of the game. But historically, inventors and companies have received patents, trademarks, and copyright protection for their creative works. So to kick things off today, we're going to spend about 10 minutes talking about historical trends in gaming throughout the United States and how our patent and trademark records reflect this change over time. So to start off with, tabletop games have deep roots, and the history of tabletop games stretches back thousands of years. So here we just have two examples, one from ancient Egypt, a game called Senet, and one from Han Dynasty, a game called Luobo. And as you can see, these games stretch back, again, thousands of years. America did not invent tabletop games. This is something that was developed in civilizations in the BCs. It has a long history of tabletop gaming in Europe. But American creators and manufacturers contributed some of the most popular and well-known games over the past 200 years. So that's really what we're going to focus on today. The American IP system, so the intellectual property system, offered more options for protection for inventors and creators of games than ever before. And we see that reflected in the historical record. So we have good examples of patents and trademarks stretching back to the 1800s, and we'll be seeing just a few of those examples today. So to put games in their historical context, we need to understand that, like any creation of culture, games do not exist in a vacuum. They reflect what's going on in a society at the time. So that can take the place of cultural norms. It can take the place, it can reflect what was popular in other forms of popular culture, like literature or other forms of entertainment. And it can also reflect major historical trends and events. Creators draw influence from their lived experience, and they also draw influence from what a society wants and needs. So we have two early examples of this in the history of American board games. On your right here, so the map of the Eastern United States, this is an 1822 game that was called The Traveler's Tour Through the United States. And this game helped players learn about the geography of a fairly new country while they were having fun. The map itself included 139 cities and towns at a time where there were only 24 states. And this was also a time where travel was much more of a challenge than it is today. So this game provided an opportunity for people to familiarize themselves with places that they had never been and likely would never travel to. But it was a way for people to connect with this kind of growing nation at the time and learn a little bit about the geography of these kind of newer states being added to the Union. On the left, we have a little bit of a later example. This is a patent received by a man named Charles Richardson for a version of War Chest that he patented in 1866. 1866 was just 1 year after the American Civil War. His game challenged players to use different branches of the military to come up with strategies and tactics to defeat their enemy. And the two sides of the board were separated by a river, which was similar to the terrain on many Civil War battlefields. Military strategy games such as this were very common at the time, and they served an educational purpose in addition to an entertainment one. And this conversation, kind of this interplay between education and entertainment, was a very kind of popular method of developing board games at the time. And there was actually some debate over whether games should serve an educational purpose or if they should be merely for having a little bit of fun with your family. So as board games became more popular throughout the 1800s, we have a lot of examples of both. So games like The Mansion of Happiness, which is on the right or the left of your screen, first published in 1843, so a very early American board game, had a prevalent moral message. Players would have to navigate through a track populated with various virtues and vices. The virtues advanced them, while the vices forced them to move backwards. This game later influenced other morality-themed games in the latter half of the 1800s. Other games, you might recognize this one, the still popular Ouija board, played into cultural trends at the time, but they were largely used for entertainment purposes. The Ouija board was invented during a spiritualism craze in the 19th century, where many Americans were interested in the occult, in that kind of perceived veil between life and death. But despite being part of this cultural phenomenon, the Ouija board was at the time largely seen as an entertaining parlor game, rather than a true method of speaking to the dead. And this kind of trend between education, entertainment, edutainment, if you will, continues throughout into what we refer to now as the golden age of American tabletop games. So a manufacturing boom in the late 19th century, as well as the expansion of the American middle class, meant that more products were being produced on a mass scale and more commercially available than ever before. And this included games. This led to an era which many historians refer to as the golden age of tabletop or board games, which occurred from around 1880 through about 1920. This was also a period of time where trademarks could be registered on the federal level in the United States for the first time. So starting in 1870, brands could register their trademark for their logo, the brand name, or even the name of the games themselves. And many board game companies availed themselves of this type of intellectual property protection in the late 19th and early 20th century. At this time, brands such as Parker Brothers and Milton Bradley emerged as toy and entertainment powerhouses, but there were also a lot of smaller, more specialized board game companies that were producing games for Americans across the country. This was also a time period where childhood was really becoming a distinctive target demographic for consumer products. And we see that a lot of these games were marketed towards families. Some kind of trends that we see during this period are tabletop adaptations of familiar outdoor games and nursery rhymes. So we see an example of that with this game of cat. Basically, this was an outdoor game that's kind of fallen into history at this point. They adapted it for a tabletop version so that people could play indoors. Others kind of fell into this education, morality lesson bucket. One example that you're still probably familiar with today is what was then called the checkered game of life, then the game of life, often called just life today. And finally, others like Tiddlywinks provided a simple fun for all ages, something accessible that many people could enjoy without having to learn a lot of complicated rules, and that all members of the family could participate in. And I think if we look back on this, we see a lot of similar trends in gaming today. Some games are simple, meant to be accessible and promote family fun. Some games do educate or teach lessons, whether they be explicit or implicit. And many games rely on familiar concepts that kind of provide comfort in a different medium. And as we moved into the 20th century, creators continued to be influenced by both their societal ideals and their lived experiences. And we have two games that you might recognize that fall into that bucket. So this patent on your left here from Elizabeth Meiji, her 1904 patent for what was called the landlord's game, described a board game with a bank, properties worth different prices, 4 railroads, and a jail. That sound familiar to anyone? So this game influenced what we now know as Monopoly. Meiji's version was a little different, though. In order to help players learn about something called the land value tax, which she was a proponent of and what we broadly consider called the progressive era, there were 2 ways to play her game. In the Monopoly version, the goal was for each individual player to get as much money as they could at the expense of their opponents. In contrast, the prosperity version of her game encouraged players to interact with each other to create new products. And this kind of led to a more even prosperity for all. An adapted version of her Monopoly track became popular during the Great Depression, and this is the game many of us have on our shelves today. In a little bit of a contrast, Eleanor Abbott's first foray into gaming was a little less political and a little more personal, but she also gave us a game that has become a classic. Candyland was born when Abbott, who was a retired California school teacher, was in the hospital with polio. Surrounded by recuperating children, she came up with the wonders of the Gumdrop Mountain, Peppermint Stick Forest, and Molasses Swamp as a colorful and entertaining distraction for this frightening pandemic. And her game is still popular with families over 70 years later. So as we moved from kind of this golden age of American entertainment further into the 20th century, other forms of entertainment, including the radio, then television, and eventually video games, became more commonplace. And because of that, the popularity of tabletop games waned throughout the 20th century. But around the turn of the new millennium, we've seen a resurgence in this particular style of fun on the global market. So new games with new trademarks and patents have taken up residence in people's homes, in community game centers, and even in both in-person and online tournaments, prompting some to declare a second golden age of tabletop games. And some even have historic themes. So we hear Settlers of Catan, now known as Catan, was influenced, its creator, Klaus Teuber, was influenced by Viking settlers in Iceland. while Ticket to Ride harkens back to the heyday of the railroad. So to modern games with some historical themes that they rely on. And to talk more about the intersection of our modern gaming world and intellectual property, I'm going to turn things over to our next speaker. But before I do, if you would like to learn more about the history of intellectual property in America, I encourage you to check out our website, which includes our Journeys of Innovation series, which focuses on a either historic or contemporary innovator every month. And then follow us on social media, where we share a lot of historic patents and trademarks as well. So I think I'm turning this over to Brian. Is that correct?
Yep. Thank you, Becky. That was great. Something that I think you highlighted very well is the fact that innovators, whether be it in the board game industry or any other industry, really take their cue from what's happening around them, right? It's about those problems that are happening around them that inspire them to innovate. So with that, we'll pass it up to Brian.
Okay. Well, thank you, Ramon. Thank you, Becky. Hopefully people can hear me well enough. And again, my name is Brian Chellgren. I'm an intellectual property attorney. I've been practicing for about 16 years. A decent portion of my practice is representing companies who are associated with or in the hobby gaming industry. And the speaker after me, Justin, is going to talk a little bit about his development and design of games, and particularly some kind of bringing back old games that have gone out of print or have expired. And so I'm sort of setting the table by talking a little bit about intellectual property, and particularly how long different forms last and when rights could expire or be available to others. So the three main types of intellectual property are patents, trademarks, and copyrights. I'm not going to talk very much about patents. There are some patents that you see on occasion relating to the hobby gaming industry where someone may a patent is a form of protection of a new or useful apparatus, composition of matter, process, and sometimes you see patents, and actually I've helped a client get a patent on a new game board, game component, physical structure usually, occasionally a method of play, but trademarks and copyrights are a lot more common, so that's what I'm going to focus on. So a trademark, most people have heard of it. Trademark is a word, a name, a symbol, it could be a logo or a color, basically an identifier of the source of goods or services. For example, if you see a shoe with the word Nike on it, you know it comes from Nike Inc. If you see no words, but you see a little swoosh symbol on a shoe, you also know it comes from Nike Inc. But trademarks are associated with specific goods and services. So Nike is a trademark in connection with shoes and athletic apparel, but Nike Inc. doesn't have a trademark in Nike in connection with tax preparation services or bulldozers. So trademark rights come into existence when a mark is used in commerce. So let's say I'm a game publisher and I'm going to make a new board game called Space War, where I have spaceships that are shooting at each other. I make the game, I offer it for sale, and then once the mark is in commercial use with the product, I have what's called common law rights in that trademark. Now, you can register a trademark with our friends at the United States Patent and Trademark Office, which makes it significantly easier to enforce your exclusive rights you have in that mark, and makes it more difficult for third parties to challenge the validity of those rights. So the owner of a trademark has a legal right to prevent others from using the same mark or a similar mark in connection with related goods or services. And this is designed to avoid consumer confusion as to the source of the goods, i.e., if you buy a Coca-Cola, you want to know that the liquid's coming from Coca-Cola and it's not some random person who put swamp water in a can and is trying to sell it. So because of this, trademarks, they avoid consumer confusion and they also protect the goodwill associated with the mark. So trademark rights can remain in force in perpetuity if the mark remains in commercial use. However, if a trademark is not used in commerce, eventually the exclusive rights that the trademark owner has can expire. So in the United States, there's a presumption that a mark is abandoned if the owner deliberately ceases using the mark in commerce for 3 or more years without an intent to resume use of the mark. So let's go back to the example. I'm a publisher. I make a great, exciting board game called Space War. I publish it in the 1990s. I have a big print run. It sells out. And here we are 25 plus odd years later. And now those trademark rights would have expired, so a different person can come along and make their own game named Space War. I mean, from a practical sense, a lot of games tend to be in certain areas, medieval fantasy, outer space, pirates, spies, horror, things of that nature. And there are only so many words in the English language associated with those different areas. So if there wasn't some mechanism for exclusive rights to expire after non-use, then eventually you'd run out of good trademarks that are available. So with the idea of a Space War game that was published in the 90s, hasn't been in print for 20 some odd years, that mark is now available for someone else to use. However, things can get a little bit more complicated if you are trying to use an old property that expired more recently, because there can be a disagreement as to whether or not a mark is still in commercial use. Let's change my example, and let's say I'm still a publisher. I make a board game called Space War, but I released it in 2019. I had a big initial print run. It sold out in about 6 months. Then I was arguing about whether I wanted to print it again, but then we had, a certain instance occurred in 2020 that was a little bit of a disruption in society and business and supply chains. And through various reasons, I decided maybe I can't do a print run for a while. And then maybe in 2023, I thought, okay, I'm going to try to put the game back in the market, but I've got some new ideas to change my components. Maybe I'll take another year to get it tweaked. And now we may be, 4 years since the mark and the trademark Space War and the board game has been in the public. But if somebody comes out tomorrow with their own Space War board game, I may still have a legitimate claim that I still have valid trademark rights in the term Space War, and that new game manufacturer is infringing. And by infringing, I mean that that someone who uses a mark that is the same as or similar to a earlier mark in connection with related goods or services, where it's likely to cause a confusion or mistake or deceive someone as to the source of those goods. Because if I had a great game, I don't want people to buy this new Space War and think they're buying my original game. So because of that, I think the short summary is trademark rights protect the identifier of the source of goods and services. They can expire over time, and other people can use those marks after the original owner's rights expire. And with that, I'm going to hop along, talking a little bit faster than I planned, with copyright. So copyright is a type of intellectual property that protects original works of authorship, such as literary, musical, dramatic, or artistic works, as soon as the author fixes the work in a tangible medium of expression. So if I am an artist and I take a paintbrush and I paint a wonderful painting, it doesn't have to be wonderful, it just has to be an original painting. I put my paintbrush down, I have copyright in the work I just created. And as the owner of copyright, I have certain exclusive rights to reproduce or make copies of the work, to distribute it, to display it publicly. If I made music, to perform it, or create derivative works based on that original work. And it's not required to register your copyright with the U.S. Copyright Office, but there are many more legal options to enforce your exclusive, for the author to enforce their rights in their work than there are for unregistered copyrights. So in the hobby gaming field, copyright is everywhere. There is artwork on the game boxes. There's artwork on the game boards. There's artwork on cards. There's artwork on manuals. There's expressive text. If you think of like a role-playing game, you can have dozens and dozens of pages describing the world, the different races, the classes, the history, who's fighting who, what wars there are, etc. And so you can have text in literary material as well. There could be copyright in the particular shape or appearance of game components if they are original and expressive works. So copyright, it remains in effect under the current legal regime for the life of the author plus 70 years. So that's quite a long time. There's a different calculation for older works that were published between 1928 and 1989, where the duration of copyright might have been contingent upon complying with certain notice requirements or filing a renewal. And works that are published prior to 1928 are in the public domain, which means they're free to be used. So for example, let's say I'm still a game publisher, but I'm no longer interested in space war. Now I'm interested in The Adventures of Tom Sawyer, an American novel published in 1876. That is well before 1928. It's in the public domain. I could make a game based off The Adventures of Tom Sawyer. I could use text from the novel in the manual for the game. However, there are a number of things you have to think about that can make life a little complicated when you're thinking about making a game or bringing back doesn't even have to necessarily be a game, but bringing back an old property or using an old property that you might believe is in the public domain, which is sometimes different parts of a work may be created at different times. Like, let's say The Adventures of Tom Sawyer again. I might have 5 copies of the book published in different years, and even if they all have the same text, they may all have different cover art on the front of the book. So the cover art on the original 1876 book would certainly be in the public domain, but if there is cover art that was printed on a version of the book published in the 1950s or published in the 1990s, that may still be protected by copyright. So even if someone comes out and says, hey, this is an old property, it's in the public domain, maybe not everything associated with it is. And one example I like a lot is The Wonderful Wizard of Oz. The original book was published in 1900, small difference there. The original book was published in 1900 and is in the public domain. However, a lot of people know about the story of The Wizard of Oz from the 1939 movie with Judy Garland, which is not in the public domain. In the original book, Dorothy's slippers were silver. The movie studio decided to make the slippers ruby or red to be more visible against the yellow brick road. So if I say I want to make a game, or even let's say I want to make a product like a flower vase and I want to have something relating to the Wizard of Oz on it, I should have my Dorothy wearing silver slippers, not ruby slippers, if I want to make sure that all the work I'm using is in the public domain. So if somebody wants to make a game on an old property that's in the public domain but still fairly well known, like Zorro, Sherlock Holmes, etc., it's important to look to see what content you're using and whether it is pre-1928 or not. And that 1928 date will move forward 1 year each year as time progresses. So with that, I'd say and I know there's been a number of questions that have popped up in the chat, and I believe questions are going to be addressed at the end. But some very brief tips to remember in this about 12-minute or so summary of patents of copyrights and trademarks is that trademark rights serve as identifier of the source of goods and services. Trademark rights are based on use of a mark in commerce and can expire if a mark is not used in commerce. Trademark rights are trademarks are things like the name of the game, the name of the publisher selling the game. And if those marks are not used, that other people can later adopt them. And for copyright, it protects expressive works. It does not protect methods of operation, rules, processes, procedures. So if you wanted to use, say, or bring back an old game, you may want to avoid using the artwork in that game because it's probably still protected by copyright unless it is a very old game. And you'd probably want to make your own artwork, write your own text for the rules, but the crunch or kind of the mechanics of the game could likely be reused without copyright issues. Like, let's say I have that Space War game again, and let's say somebody else wants to come back and make a new version of Space War. In the original game, perhaps you roll 3 dice and you have to get a 15 or higher to hit a fast enemy ship, or a 12 or higher to hit a big slow enemy ship. You could use that same sort of mechanism of 3 dice to hit and different numbers based on different speeds of enemies or whatnot, and that material would not be protectable by copyright and could be reused. Other take-home messages: don't use a well-developed character like a Dorothy or a Harry Potter or a Luke Skywalker unless it's in the public domain. Or don't use prominent features of characters like Ruby Slippers that are not in the public domain unless you get permission from the IP owner or unless you want to fight. And I can tell you, legal disputes are expensive. However, if you are thinking about something like a generic character, like a sheriff, a gladiator, a space cowboy, etc., that doesn't have a big, long backstory or isn't fleshed out like a Dorothy or a Luke Skywalker or Harry Potter, then those sorts of generic, undeveloped characters are generally considered not to have enough expression to be protectable by copyright. And with that, that was what I had prepared, and I'll pass it along to Justin, who can give a more concrete example of making a game and thinking about other IP when doing so.
Beautiful, Brian. Thank you so much. Just before Justin, yeah, we have a lot of questions in the chat. Some we'll try to address them at the end. Just remember that some of those may not be addressable at this point, but USPTO.gov for all your best place to find a lot of those informations. Okay, and don't forget to subscribe to our mailing list so you don't miss out. If we release this in the YouTube channel that we have, USPTO has a YouTube channel, the recording, or certainly any other events like this where we could probably answer those questions like the patent, like the patent bootcamp and the trademark bootcamp, because I know there are some very interesting, deep questions. Okay. But Brian, thank you so much. Justin, go ahead, take it away.
Yeah, I'm probably going to talk a little quicker and more succinctly than I planned because I was keeping an eye on that as well. And there's definitely some good questions in the chat there. So I want to make sure we have time to hit as many of those as we can. I want to thank Ramon and the USPTO for putting this on. I think this is great. Especially in today's current climate, sometimes we don't think of government as a resource and a helping hand. And in this instance, at least, it very much is. So I encourage all of you who have questions, go to USPTO.gov. There's lots of resources there, and check that out. Games, I always said, are sort of in a unique place because they're a combination of both art and science. And that's what makes it so interesting for the application of intellectual property. Things that are purely art, like paintings and things, are sort of in some ways easier to apply these principles to, or some things that are purely technical, like a computer chip or something. When you have something that combines aspects of both, it gets a little murkier, a little bit harder to do. And the interesting thing is, as you know, I was a lawyer for a long time, law is in a lot of ways the same. There are definitely some rules, but how they get applied and interpreted is very much more of an art than a science. And a lot of it depends on who you're arguing to. I'm sure Brian can attest to that. So importantly, I think my big takeaway is there's no like certainties. There's no hard and fast rules. Like all these great things that we're outlining can change depending on who you're making that argument to. And so my big takeaway is if you really have a big issue and it's something you're seriously considering, is probably consult with an attorney and get some more detailed advice for whatever you're looking at. But I do want to talk about, so we publish old games. We take old games that have been out of print for a while that we think people will be interested in, and we modernize them and bring them back. And I just want to talk about a few sort of specific examples of how we do that for these games, just to see how these intellectual property principles apply to a real world example. So the first one I want to talk about is Dinosaur Tea Party. And this was based off a game called Who's It from 1976, which was essentially, I forget who did it, the Parker Brothers, I think, was their answer to Guess Who. Everybody knows Guess Who, right? Yeah, you flip down the people. Is your guy wearing glasses? You know, is it a man or a woman? All that stuff, where you're trying to guess who the person is. So it's a very similar game to that, but it was multiplayer and it had some cool things to it. One of the being that certain people in the game had traits where they could lie or they would always say no or whatever. And we thought that was a cool hook, so we wanted to bring it back. So when we did that, first of all, it had been out of print for decades. This was 1976. So clearly no trademark issues here. But importantly, one of the things we consider is we always look at some of the constraints of this intellectual property and turn them into opportunities. So for us, if we're bringing back a game and we want to, one of the things we want to do is differentiate it from the original. If we're not doing a strict reprint, if we're strictly reprinting something, we would say, hey, this is this game. And so that the people who are familiar with that will know what they're getting into. But when we're changing the game enough, or if the game wasn't itself popular, we just think there's something mechanically interesting, we'll switch to an entirely different name that we can trademark that's more identifiable. So in this case, Dinosaur Tea Party is a catchy name. It's a fun name. And so that was something that was easy. So it was a new name. It was a new theme. Interestingly, this was a game where it was a bunch of people. They were photographs instead of illustrations. There were a lot of, as you might expect from the time period, some unfortunate racial stereotypes, for example. And when we were trying to update it, we were like, when we were looking at how we sort of sliced these characters up into their discrete characteristics, we kept finding it a little awkward. And so that was when we decided to switch to dinosaurs, because no one would be offended if we asked if your dinosaur had stripes, for example. So again, this opportunity presented an opportunity for us. So we had a new theme, a new name. It was an uncredited designer, and there was no fiction to the game. So one of the interesting things is, while mechanics can't be protected by copyright, the actual specific, as a general principle, again, everything is general principle here. There is an interesting case, Brian knows about it, I'm quite sure, that what we call the Bang case. There was some interesting dicta, which is lawyers for like conversation around the legal issue, not specific to the holding, where the judge basically said, there might be a situation where the rules themselves create a recognizable fiction that could be protected by copyright. So we always get, I'm going to talk about this again in a little bit on a different example, how it's something we considered, where, if the rules provide essentially create a specific story in play, or a specific expression of a tale or a theme or something like that, theoretically you could come up with a copyright issue. Again, we didn't have that here. So this was a real easy one for us. There was no designer to contact, long out of print. We weren't using any of the same art. So we just did the game, right? We weren't worried about it, no problem. That's sort of like the easiest one. And for us, every time we do a project, I'll say this, they're always different. No two games that we're looking at end up being the same. So the second one I want to talk about is one of our very popular lines. It's called Unmatched. This is a game that we brought out in 2019, and it's been going ever since. And it is based off a game called Star Wars Epic Duels from 2002, which was a very cool fighting game where it basically had like 20 characters from Star Wars, and each one had their own deck, and you could take any character and fight any other character. So you could have like R2-D2 fighting Darth Vader if you wanted to, right? And we thought that was a really cool system. And this idea of this, so Ramon's holding it up, this idea of a modular fighting system where each character was very specific to itself was a very neat concept that we wanted to elaborate on. And we, of course, didn't have the Star Wars license. So that was a real easy one. We knew we couldn't use Star Wars characters because we didn't have the rights to that. But again, we took that and saw that as an opportunity. And so what we did do is we released some public domain characters. So our very first set was Battle of Legends Volume 1 and includes Alice in Wonderland, Sinbad, Medusa, and King Arthur, right? All clearly public domain characters, easy to use. So again, we use that as an opportunity. But then as we expanded the line and it grew in popularity, we also were able to mix in license sets featuring famous intellectual properties. So we had some Jurassic Park sets and we had some Marvel sets where we licensed the right to make those characters in the system. But then we also have public domain sets. We just came out with a set called Slings and Arrows that features characters from Shakespeare, again, easily in the public domain. But again, one of the interesting things, I know Brian talked about this a little bit, but I want to expand on one thing is when we talk about something like Zorro or Sherlock Holmes, one of the really interesting things that a lot of people can overlook is even if a character, even if one part of a character's story is in the public domain, and yes, there might be some more, so Zorro is a good example, right? The very first Zorro stories, some of those are in the public domain. Some of the later published ones are not. But what's interesting is that there is a company that has the rights to Zorro, the trademark rights to Zorro. So some of the signature elements, the mask and the signature Z and the name have all been trademarked. Now, there is some ambiguity about how enforceable that is, but when it comes, if you're talking about, whether you're going to win your lawsuit, you've already lost, right? So just keep in mind that there are some of these characters whose works might be in the public domain, but still might be subject to claims of trademark that you need to deal with. So that is one of the reasons we don't have Zorro in Unmatched yet. You never know. And then the last one I want to talk about is sort of our big game. Ramon's got the prop right there on the table, is Return to Dark Tower. This one is a fascinating case study. This was a very popular game from 1981, originally called Dark Tower. And we knew when we started the company, we wanted to remake this game because of its popularity. But it was challenging. Like there were a lot of issues and it was very convoluted. The legal history of the case is convoluted. So the original game was published in 1981 by Parker Brothers, I think. Anyway, what had happened was there were designers of a game called Triumph that went to Parker Brothers and said, hey, we have this game. We want to, as inventors, we want to sell you the right to make this game or license the right to make this game. They considered it and then declined to do it. And then a year later or so, they came out with Dark Tower. The game Triumph that they pitched had a large mechanical tower in the center of the board. So there was this huge similarity here. And it was an interesting case. I obviously can't get into all the details of it, but what was particularly interesting about it is there was a non-disclosure agreement that the inventors signed that made the Parker Brothers made them sign so that they could speak with them. And then what their actual claim was not any of the stuff we've talked about here today, but was a misappropriation of trade secrets, which is yet another branch of games. Certainly not something that comes up very often, but I mention it because it's sort of an interesting quirk to this legal case. Convoluted case. They lost. They won. They lost, and there was an appeal, and then they finally winning when it got remanded on appeal. And so they end up winning this case. So when we wanted to do it, we were in this posture of having this. It had long been out of print. So they did this one big print run. It was the hot game for Christmas that year. But with all the legal issues, they never reprinted it. So it was literally only one print run in 1981, and then that was it. So it had long been out of print. But there are all sorts of issues, like who actually had the rights to any of it. There was this because there was these other issues. These were things we had to consider, and then also the question is, I talked about before, is like the nature of the story, that there's a large evil tower in the center of the table that you're adventuring to try and get into and defeat. Who's living in the castle. The original game had names for the kingdoms. So we had to make all these sort of individual decisions about what we were going to use from the original game and what we weren't. Some of those were legal questions we had to answer. Some of those were things we thought would be better for marketability. Some were for gameplay. So there's all these issues that go into it. So the sort of the takeaway is every case is different. And then the one thing I want to mention is, in addition to all these legal considerations, right? There are ethical considerations. And that's important not just to do the right thing, but also because if you ignore them, you can get a lot of bad press for yourself. You can sort of have your game get tanked before it even comes out. There have been cases where people have stolen someone's idea. That's been largely corroborated, and the game, tanks. Like or it never ends up never getting published because of the bad press. Even if that designer never had any enforceable intellectual property rights anyway, right? There's this big gray area, right? Like a lot of board games are built on the concepts and ideas of the games that came before them, and the games have been around forever, as Rebekah pointed out. So coming up with something truly original is very challenging. And so, how much of it relies on something else? How much of it is original? What are you doing with it? These are all really important questions. And so I would say for us, and that's just one piece of advice, if you are planning on doing something that's based off of an old game like we do, first thing we always do is we contact the original designer if we can find them. Again, even if they don't have any protectable legal rights, we think it's just the right thing to do, but it also can make the game better. It can eliminate a lot of ambiguities about where certain pitfalls might be for intellectual property and things like that. So that's sort of my other big piece of advice, I guess I would say. And I think I talked really quickly because I saw, again, we were getting tons of questions, and I think the questions look really good. So I thought I would wrap up a little early and give us more time for questions, if that's okay with everybody.
Beautiful. Thank you so much. I was actually just setting up the tower for the new version of that tower, although because you have app integration too. Do you want to talk a little bit about that?
Sure.
And then I'll should go. So not only for that tower, but as now the innovation that we have, integration of digital and hardboard, I guess. Yeah, analog and digital all together.
People, I know there have been questions about patents and how rare they are. This was actually one of the questions we had to answer. So the original tower was essentially a computer in the tower itself. And it had a little keypad that you would press buttons on. It lit up, made noise, it spun around. It's very cool for its day. When
1982, right?
81.
81, there we go.
When we were getting ready to do it, we were like, oh, we got to make the tower really cool. And we just, every idea on the table, brainstorming ideas for how to make the tower as cool as possible. And ultimately, we kept going back to the fact that there is nothing we can do as powerful in this tower that is even a tenth as powerful as the computer that everybody has in their pocket right now, right? So we decided pretty early on that we were going to leverage the power of that smartphone, right? And what we were going to do is give the tower something else cool to do. So what we did is we brought in these physical elements. So the tower itself is hollow. We wanted to make it sort of an important ritual and focus of the game. So it does sit in the middle of the table. And what we did is we have these cool little plastic skulls. And at the end of your turn, you drop a skull into a hole in the top of the tower. There's an IR sensor at the top. It recognizes that a skull has gone down. Inside the skull, there's these little baffles and platforms, and then there's openings on the sides of the tower. Some of them are covered up, some of them they get open during the game. Sometimes the skull gets stuck in the tower, sometimes it comes out. But when it reads that trigger with the IR sensor, it sends a message via Bluetooth to the app that we have, the custom app, that says this person's turn is over. And that's when the tower gets to take its turn and do all its nasty events and all that stuff. And so one of the things we actually talked about was whether or not we wanted to patent that particular sort of innovation that we had done with this technology. We feel like we probably could have. So I will say, I see some questions about patents. So there are certainly things you can patent, like it happens. If something's truly innovative, you can patent it. That's what it's for. It's just not usually very practical. So here's a specific example, right? Like no one else has come out with something similar to the tower. Not going to happen anytime soon, I don't think, because it's a real pain in the butt. Tabletop is not like video games, right? There's a lot more money in video games. If you want to just get rich, my suggestion is going to video games. But I just don't know how practical it is for a patent, even if you could get one, because they are more limited in time. certainly than copyright, but also they're not in perpetuity like trademark, right? They last for a very specific period of time, depending on whether it's what type of patent it is, without getting into too much of the details. But it could be like 10 years or 15 years or whatever. So, how much is that really going to help you? So
And
anyway, that was, where we
I
landed.
actually wanted to amend that. I think that whether you decide, and I think you were saying it's just that whether you get a patent, whether you protect your intellectual property through a patent or a trademark or a copyright, et cetera, it's at the end of the day a business proposition, right? Does it make sense for your business? And does it make sense for your business to protect it like that at that time? Maybe for something else at a later time, you want to say, oh, yes, now it makes it makes sense to use the patent, et cetera, et cetera. So, but yeah, I think it's very interesting that innovation that's happening right now with games. So my first question for you, Justin, and I'll go in reverse, right? And then we'll take some other questions from the chat as well. And I'll full disclosure, I'm stealing this question from somebody else, but it's such an apt question for this discussion. Which is the most innovative game you've played?
I played?
Yeah, or do you know the most innovative
I
game?
made. That's good.
Well, it's up to you. You can use your own IP or somebody else's.
I'm not that egotistical by that much. That's a great question. So it's funny. I'll say this. I mean, it's hard to pin down one, but I think this is a really interesting example and also a nice little story to sort of tie into everything we've been talking about. My business partner is Rob Davio, legendary game designer. He worked at Hasbro for 20 years or whatever it was, worked on a number of games. He made the best version of Monopoly you've ever played, Tropical Tycoon. If you get a chance to play that version, it's great. One of the things he did is sort of, as he got towards the end of his tenure there, they sort of let him do this pet project, which turned out to be Risk Legacy. So for those who don't know, it's the classic game of Risk where he had postulated this idea of, for Clue, is like, why do people, if they keep dying, why do they keep getting invited over, that sort of thing? Like, essentially that the story resets every time. And it gave him this idea to make a game where the story did not reset every time. And he ended up applying that concept to Risk, where you would write on the board and put stickers on the board and tear up cards and all these things that were just, no one had ever conceived you would do with a game before, right? Like, where you're changing the game as you play it, and it develops a story as you play it. And that was literally how I met Rob. I used to do a legal Q&A seminar at Gen Con every year, mostly as a way to write off the trip as a business expense. But I would meet people there, and I would end up being my clients. Back when I was practicing law, I would get clients in the game business who I would do mostly pro bono work for, but some other stuff. And I done a Q&A seminar, and Rob's wife afterwards said, hey, can we take you to dinner? Rob was getting ready to leave, and he wanted to do Legacy. And he was sort of like, what could he use? And, what could he apply it to? Should he apply for a patent for it? Which obviously wouldn't work because they had already published Risk Legacy. There were apparently, I don't know the specifics, but there was obviously some talk of whether or not they were going to patent it, and they decided, who's going to do, what's Legacy? No one's going to care about that, Obviously, it turned out to be a very big thing. But anyway, it's just an interesting question. So I do think I'll say Risk Legacy, because I think that concept of like a game that changes over time was pretty remarkable.
It is. I'll have to say that the first time I played, obviously Rob Davio's design as well, Pandemic Legacy, right? And the first time I broke that card was like mind blowing. It's like, what am I doing? Because we have this concept of games are forever, right?
Well, there's a twist in that game that literally is my number one game moment of all time. I highly recommend, if you haven't played Pandemic Legacy,
you should
play it. That's
absolutely.
my advice. That's my one takeaway for this whole talk.
Oh no! Thank you so much, Justin. I will say for me, because I don't think it's fair if I don't answer that question. Cat in the Box. Have you ever played Cat in the Box? And again, there's something about innovation, right? There's something about entrepreneurs and innovators that they take things and they see them in a different way, right? Like Rob in that particular case, in which he takes a game that normally we think of it as something that's forever, right? And he said, you know what? Maybe this is disposable. Maybe we can change the game, can evolve as you play it, and the game can reflect that, right? Cat in the Box is a trick-taking game, and we're so well familiar with trick-taking games, right? I'm sure Rebecca has many examples of through history we've played trick-taking games. In Puerto Rico, one of the ones more popular is an Italian trick-taking game. Anyway, in this game, the cards don't have suits. So how do you follow suit? And you get to choose which suit it is. And the first time, again, just like that experience with pandemic, the first time I played that game, I was like, oh wow, it's kind of mind-blowing how all the cards are black, like the black cat for the cat in the box. So yeah, absolutely, that's for me. And Brian, for you, I have a question. What are the most common IP challenges a board game designers can face today? And if you can weave in or want to talk a little bit about crowdfunding and in an ID design, if you want to, please do so.
Okay. Yes, it's very crowdfunding. A lot of publishers do that where they announce a game, they put it on Kickstarter, they hopefully get funded, and then they hopefully release the game at a reasonable amount of time after that. It's a common process. It's sort of interesting from the trademark perspective, and this will kind of jump back to, I think, one of the questions I saw in the chat, which somebody asked something about whether Kickstarter or other crowdfunding sites kind of count as using a mark in commerce, or what does it mean when you use it? And I think there was another question who asked about when you can apply for it to register a trademark. So you can apply to register a trademark before you use it in commerce, but you won't actually get the registration until after the mark is in commercial use. And there is a limited amount of time, even though it's a number of years, after the trademark office says, yes, okay, you can register your mark, you have a limited amount of time to put the mark in commercial use. Kickstarter does not qualify as commercial use of a mark. In order for a mark to be used in commerce, it has to be, you can use a trademark with goods or services. Services, you have to be providing those. If I have an air conditioning repair service, I have to be out fixing air conditioners, or I have to be standing by the phone ready to fix an air conditioner the minute somebody calls. If it comes to goods like products, like let's say board games, you need to have a game on a shelf, you need to have a game maybe on a truck being delivered to a store for someone to purchase. But if you just start a Kickstarter, yes, you are using that mark out in public and people can see it, but there's no guarantee that there is never ever going to be a product that actually is sold under that mark. Because unfortunately, not every Kickstarter funds, and even if Kickstarter is funded, it doesn't always result in the product actually being mailed to the backer. So I sort of talked partially around your question, but I was trying to catch one or two of the ones from the chat. But if you wanted me to say something different about or in addition about crowdfunding, I'd be happy to do so. I have some clients who don't use it at all. I've got other clients who crowdfund every game they do.
Beautiful. No, that's perfect. I think that just getting yourself well educated about intellectual property, right? And the different ways that you can protect the intellectual property that you are generating through the games that you are making, right? Or the innovations in general, right? Is so important. Because examples like what you're saying right now with crowdfunding, which being a very popular platform that everybody uses. And again, similar to what Justin was saying, does it make sense for you in your business to use that platform or not? But regardless, you need to understand very well how that IP plays into that decision as well. So thank you, Brian. Now, and there goes the tower. I don't know if you guys can hear it. Becky, for you, I have this question. What can modern game designers learn from the IP challenges faced by creators in the past?
Yeah, I think that's a great question. I'll try to keep this brief since I know we're running short on time. So I think that modern designers can learn quite a bit from the past. I think modern designers naturally kind of learn from the past just because most designers are playing these classic or these kind of vintage games as well. But I think probably kind of looking at the historical context around gaming, really identifying what makes your game not only unique, but what makes your game unique for the time period you're trying to promote and deliver your game. And so I think what Justin says about modernizing some of these older games is a really useful kind of way to look at things. Like, how can you take a universal concept from a past game and alter it to fit a contemporary audience? That's something that I think a lot of people can draw inspiration from. So we see a lot of through the IP system, and then just through kind of creative property as well. You have echoes, right? You have kind of concepts that are, you see throughout generations, throughout the ages, things that appeal to an audience or appeal to consumers, no matter what age bracket or even age they belong in. And so I think you can kind of take some of those, taking a look at some of these really popular or successful games from the past, seeing what kind of that human element, what really reaches the consumer and what makes them popular, and then trying to focus on that rather than coming up with the not that you don't want to come up with like brand new ways to do things, but you can also build on what's already there. And we see that with inventions. The vast majority of patents, the vast majority of inventions are building on existing inventions and making them better and slow incremental improvements over time. And that's kind of the case with kind of cultural phenomenons like games as well.
Beautiful. Thank you so much. Absolutely right. Most inventions, regarding on the complexity, they're based on what's we know, right? It's standing on shoulders of giants. Now we had a lot of questions in the chat. There's really no way for us to address the wealth of knowledge you guys. However, for a lot of those trademark questions, I did see so many trademark questions. I want to direct you guys to uspto.gov/events. And there you can find the next trademark bootcamp, in which one of our trademark attorneys guide you through the entire process from what's a trademark to how to apply for a trademark and actually apply. And I actually know very many people in the board game industry that have gone through the boot camps and have used that information to write there and then apply themselves. We always suggest you get a representation. We understand that the process may be complicated, so please, we suggest that you get representation. However, it's not necessary. You can apply yourself, become a pro se inventor, and apply for that patent yourself, or apply for the trademark, okay, as well. But again, USPTO.gov for all those very detailed questions about trademark, patents, etc., etc. And I think we've addressed a lot of those other questions that we have. I want to thank again Becky from the USPTO, Brian from Gamma and an IP attorney, and Justin from Restoration Game, of whom I'm a fanboy, of course, with all your IP that you're producing. So thank you guys for coming here, and thank all of you for taking time of your day and listening to us. I hope you guys find that this informative and entertainment, and hopefully we'll get a few more of these talks in the future. Bye.